Okay, picking up where I left off on the previous DVD, we were on speech. One of the most important protections in the Constitution, protected both against the federal government and against states as incorporated under the 14th Amendment. And the basic structure of most of the discussion of freedom of speech is going to be this, as I started to say and start to go through. Number one, there's some general considerations that apply for all speech cases, or most speech cases. And then there are two kinds of regulations. There are content-neutral regulations that are subject to one approach, and there are content-based regulations that are subject to a different approach. So general considerations, content-neutral, content-based will be the division of our discussion. The general principles I talked about in the previous DVD, they include that regulations should not be vague, they should not be substantially overly broad, they should not allow of discretionary enforcement, because then the official who has discretion gets to decide, and that chills speech and might forbid the wrong kind of speech. And generally, prior restraints are prevented or are unavailable under our Constitution, as opposed to subsequent punishment, which is much more likely, at least. Prior restraints, definitely stronger protection against them. Okay? Now, that being said, as general principles, we get into the content of the legislation that's being looked at. If we have legislation that is content neutral, has nothing to do with what's being said, but rather with where and when it's being said, that's called content neutral time, place, and manner regulation. And if it's a time, place, and manner, where can one speak, when can one speak, and how regulation, then it is not subject to strict scrutiny, but to a lesser kind of scrutiny. That is, the courts will say, okay, content neutral time, place, and manner, we're going to apply some lesser level of scrutiny. But before I get to the exact scrutiny, we need to distinguish where the place is. If the place where the speech is occurring is either a traditional public forum or a designated public forum, we have one set of rules. If it is a limited public forum, we have a slightly different set of rules. And if it is a non-public forum, you can't speak. So traditional public forums are places like parks, streets, the steps of the Capitol building, places where traditionally people would go to communicate to the public. Designated public forums are places that, although they would not be available to the public generally, have been designated by some state agency as being available for speech. So suppose that a town has an auditorium that it does not use during evenings and weekends, and it says this auditorium is available for rental for those who want to have meetings. If it's available in general to the public, then they can't say it's available to the public but not for religious meetings. School building has rooms that are available to the public for meetings of all sorts in the evenings and on weekends, but no religious meetings. That would be content, not neutral, but content-based. But as long as it's designated as a public forum, it's got to be content neutral, okay? That's a designated public forum. Limited public forums are somewhat different. If the town or a school calls for a meeting, we would like a meeting to discuss teacher pay. We would like a meeting to discuss police relations with citizens. By designating a place for a limited discussion on a limited topic, it does not now become a designated public forum, but rather a limited public forum, limited to a particular subject. So therefore, it doesn't have to be content neutral, it can be content based. We are holding a meeting in this place that's not a public forum on the subject of police relations with the community. That's fine, content based, so long as it's viewpoint neutral. That is to say, it can't say, but the only people who can speak have to speak in favor of the way the police are now relating, and can't be critical, can't be content, can't be viewpoint based, can be content based, but has to be viewpoint neutral. And then finally, we have non-public forums, something that appeared in a recent Connecticut bar exam essay where a father wanted to complain about something the school had done and went to the principal's office and insisted on going into the principal's office. That's a non-public forum, no right to speak whatsoever. So we have these four places: traditional public forums, designated public forums generally available to the public, limited public forums available for a limited purpose, and non-public forums. As to traditional public forums and designated public forums, if legislation is content neutral, legislation or regulations are content neutral, and they are only about the time, place, and manner of the speech, then the court will review them using the following level of scrutiny. They must be narrowly tailored to advance an important, significant governmental interest, doesn't have to be at the level of compelling, and they must leave open alternative avenues of communication. That's the test. Learn it. Content neutral, time, place, and manner, if that's what we've got, has to be narrowly tailored to promote some important governmental interest and leave open alternative avenues of communication. Perfect example. The state has a statute that says that people can speak on the steps of the state capitol building, can hold speeches and rallies on the steps in front of the main entrance to the state capitol building, but may not do so during certain designated hours, which are 8 to 9 a.m., 12 to 1 p.m., and 4 to 6 p.m. on the steps of the capitol at the main entrance. Now that's narrowly tailored to advance the interest of allowing employees and others to get in and out of the state capitol, and that's going to be fine. But a statute that says there will be no speeches given anywhere within 100 feet of the state capitol building would not be narrowly tailored. It'd be hard to imagine what important interest would be addressed by that very broad limitation. So narrowly tailored to advance an important governmental interest and leave open alternative avenues of communication, as in you can speak elsewhere and you can speak even there, just not at those limited periods of time. That would be the rule for public forums, traditional public forums, and for designated public forums. If we have a limited public forum, that's where the state agency says, let's have a meeting on the issue of police brutality or on the issue of teacher merit pay raises. Then regulation is appropriate so long as it is viewpoint neutral. We allow people to speak, but we limit each person speaking to 5 minutes, so that's so that we could actually have a discussion where everybody gets to speak. But we can't say you can only speak if you're supporting the police's point of view, or you can only speak if you're in favor of merit pay for teachers. It's got to be viewpoint neutral. And non-public forums, no right to speak. Now that is summarizing a fantastically large number of cases, and I simply want you to now look at the case squibs with this basic structure in mind. Second major area, if we don't have content neutral legislation, but rather have legislation that refers to the content of the speech, certain kinds of speech will be treated differently, will be punished in some way, or are prohibited. That is the core of the First Amendment. Right? That's where the regulation is really of speech as speech on account of its content. And therefore, as one might imagine, fundamental rights kind of analysis, strict scrutiny. Content-based regulation will be upheld generally only if it is necessarily related to a compelling governmental interest and the government has the burden of proof. Just our basic strict scrutiny. Anytime you see regulation that distinguishes or punishes or whatever on account of content of the speech, it must meet strict scrutiny. The government must show that the legislation is necessary to advance a compelling governmental interest, with a big group of exceptions. So this is like hearsay and exceptions. This is content-based strict scrutiny with exceptions where we don't need strict scrutiny. And that comes in some limited areas that I'm going to talk about briefly, where we don't apply strict scrutiny as such. Number one is where we have it. This began with a famous case in which Justice Holmes said that the state can prohibit and punish someone for falsely shouting fire in a crowded theater. Someone falsely shouting fire in a crowded theater endangers people by the very words spoken, and so the effect of the speech is to create a risk of clear and present danger of imminent lawless behavior and people getting stomped on. But by evolution over a period of 80 or 90 years, it has rather become a test of incitement to imminent violence. That's the present test, incitement to imminent violence. So if a speaker is inciting a crowd of people to do immediate violence, we're standing outside the state capitol and I'm on my soapbox and I say, those GD legislators are trying to take my guns away. Let's take our guns in there and show the suckers the value of the Second Amendment. If I'm inciting people to imminent lawless behavior, violence, and I have a substantial probability of causing this immediate violence, then the state can punish me for that. Don't have to show a compelling governmental interest, although it seemed like one actually has a compelling governmental interest. Incitement to present lawless, dangerous behavior, number one exception. Number two exception, established in a case back in the 40s, fighting words. If there are words spoken, a statute that says certain words when spoken create a danger of imminent response, challenge one to fight, a statement to someone that is likely to lead not to a discussion but to immediate violence, fighting words, then the state can forbid those. The problem is, for the last 50 or 60 years, every statute attempting to punish someone for fighting words has been found unduly vague, using our unduly vague or overly broad test. But in theory, at least, a statute that is sufficiently narrowly drawn can punish someone for using fighting words. Number three, obscenity. Obscenity is not what might be thought of as obscene in the general public, but applies a test established in the Miller case, the details of which you should read and go over in some detail. Under the Miller test, if the words are ones that appeal to the prurient interest, a word that's not in common usage but means a disgusting appeal to sexual behavior. Prurient interest appeals to the prurient interest of an average person and are patently offensive using community standards. Doesn't have to be a national standard, offensive within the particular community. Pardon me. And then they do not serve any serious social interest using a national standard. They're lacking in any political, educational, social value part of the dialogue of the public, then they may be forbidden as obscene. That's the general rule of Miller. There's a lot of court supervision over juries to make sure that the juries don't impact too much speech. Little aside, how does one decide whether a particular thing meets the test of obscenity? Well, the judges have to view the thing first in chambers to decide whether it merits even being discussed by the jury. And at least I can remember a time when in the court where I was clerking, one of the judge's clerks borrowed one of the obscene films that the judges had viewed and took it and had a little party with the clerks, with the other clerks, watching it and discussing whether it met the test of obscenity. Okay, so there must be a decision by the court that there's sufficient evidence for the jury to find obscenity. This court supervises this fact-finding pretty carefully, and then the jury must also find it obscene, in which case then it can be forbidden. Tremendous amount of detail on obscenity, lots of case squibs, read them, expect one question on obscenity. What is or is not obscene, and know that we don't apply strict scrutiny if something is obscene or even close. So The standard for deciding whether something is can be regulated is different if it involves minors. If it involves minors, we don't have to meet this test of obscenity because the court wants to protect minors, and therefore we don't use this whole set of requirements, okay? If what we're talking about, if what we're talking about is regulation of places that sell sexually explicit materials, again, the court has special rules here that allow for erotic zoning, erotic zoning of all things, right? As in, they say a town can say all shops that sell erotic materials must be located in a particular area, a defined area, and that doesn't need to meet a compelling interest standard. The court says there is an interest that the town can have in avoiding the associated behaviors that tend to be attracted by erotic sex materials shops, and so they can put them all in an industrial area away from residences. But again, read the case squibs on obscenity. Expect one question, very likely, on obscenity. So that's clear and present danger, fighting words, obscenity, defamation. Fourth area in which we don't apply strict scrutiny as such. The case that began this all, New York Times against Sullivan, is one that came up in torts, because defamation is a tort, two torts: libel for written, slander for oral. Defamation. Defamation is statements that are injurious to reputation. And the common law said a statement that's injurious to reputation, that is published, that is about the particular plaintiff and causes damages, entitles the plaintiff to collect damages or to collect damages. Just to collect damages. But in the New York Times against Sullivan case in 1966, 67, somewhere in there, the court faced a challenge by the New York Times saying, if the common law of defamation applies just the way it is to us, then we cannot fulfill our function in our system of criticizing public officials, of communicating to the public about public officials, because the risk is if we make a mistake, or arguably make a mistake, then a jury can find damages that will put us out of business. So every time we print something that might be critical of a public official, a jury that might be selected from a jury pool that does not particularly like the New York Times, might be biased against the New York Times because the person we're speaking about is perhaps a public official in South Carolina, then the jury can say, the injury was $200 million and New York Times loses, and we go out of business. So, in order to protect free flow of information by the press and others about public officials, the court laid down a standard that says the common law of defamation has constitutional limits. When the plaintiff is either a public official or later expanded to a public figure, whatever that means. I'll give you examples of public figures: Cher, Madonna, Janet Jackson, Brad Pitt. People who have access to the media, who are all the time in the media, who are very public. Those people have an extra burden of proof before they can collect. Yes, they have to prove all the common law elements, but they have to prove something more. At common law, truth of the defamatory statement was a defense, and the defendant had to prove that the statement was true to get out of or to avoid liability. But under New York Times against Sullivan, the plaintiff in the defamation case must prove that the statement is false. Burden to prove the statement's false. Number one. But even more onerous, perhaps, is that a public official or a public figure must prove that the defendant, mental state, either knew the statement was false or acted with reckless disregard of truth or falsity. In other words, that's called malice. Malice means either, very similar to murder, where we use common law malice for murder. Here's common law malice as part of the plaintiff's case in defamation. Same thing. Must prove either knowing the statement was false, defendant knew the statement was false and made it anyway, or the defendant acted with reckless disregard of truth or falsity. The defendant rather knew that he didn't know whether the statement was true or false and didn't care. Took the chance anyway, very similar to the way we use malice in proving murder. So the plaintiff has this burden of proving this mental state of the defendant and falsity. And what's more, in a later case, the Supreme Court said, and by the way, the plaintiff must prove this not by a preponderance of the evidence, but by clear and convincing evidence, a much tougher burden for a plaintiff in these cases. And still later, the court said, and by the way, the judge, in deciding whether there's enough evidence to get to the jury on a motion for summary judgment or later on for other motions for directed verdict and so forth, the judge must consider not only is there some evidence on each of these points, but whether the evidence is sufficient that a reasonable jury could find the proof was by clear and convincing evidence. All of this is designed to make it harder, much harder, for the plaintiff to win if the plaintiff is a public official or a public figure claiming defamation. Protects defendants in order to encourage free flow of information. Next, or in addition, the court said, even if the plaintiff is not a public official or a public figure, if the plaintiff is a private person who has voluntarily gotten involved in a matter of public concern, then the plaintiff must prove falsity again, but also must prove at least that the defendant was negligent in making the statement. Has to prove they were unreasonable. Doesn't have to prove something as high as knowing disregard, or reckless disregard, but has to prove at least that the defendant was negligent. Those standards on regulation of speech are accepted from the strict scrutiny. Okay? Apply that to defamation cases. Also apply that, see the outline, to invasion of privacy cases like the Jerry Falwell case that you should see in your outline. Falwell, as you may or may not know, was a minister recently deceased in the last year or two who was a member of the religious right, as we call it, very conservative, very against modern, free-thinking, overly erotic communications, very conservative in this. And so Hustler magazine, which is the opposite of Jerry Falwell, a magazine that is just known for smut and junk and crap, published a piece about Falwell, in which it said that Jerry Falwell had been introduced to sex in an outhouse by his mother, something, I mean, just really absurd, stupid stuff, to mock Jerry Falwell. Falwell sued. His lawyer said, wait a second, we're not going to win in defamation because we can't prove that this was meant to be a factual statement and so forth that was intended to communicate a fact. Let's sue for an intentional infliction of emotional distress or invasion of privacy. The Supreme Court said same standards apply even when we change the name of the tort. In order to protect the speech, we use the same standard of, in the case of Falwell being a public figure, we're going to use the standard of did the magazine make a statement of fact intended to be understood as a statement of fact, which pretty obviously not, and if so, did they make it with knowing disregard of truth or falsity? Here, it's simply not a statement of fact, I suspect. Okay? Defamation. And our final big category here, we've been through what? Clear and present danger or incitement to imminent lawless behavior, fighting words, defamation, obscenity, and the last category that is not subject to strict scrutiny, commercial speech. Speech for commercial purposes can be forbidden because the speech is deceitful, is filled with lies intended to take money from the public. False and deceitful advertising can be forbidden. But if the advertising is not false and it's not promoting an illegal activity, speech saying, I have 3 pounds of cocaine for sale, come over to my house and buy it, that can be forbidden because that's inviting people to engage in illegal action. But if the commercial speech is not false advertising, is not an invitation to do an unlawful activity, then the government can still regulate it a little bit under a somewhat lesser standard than strict scrutiny. It can regulate it if it has a substantial governmental interest, not compelling, substantial governmental interest. The interest is advanced, directly advanced by the legislation, doesn't have to be any more than directly advanced, but it also has to be narrowly tailored. So it's a lesser standard that the statute must meet, or the test, the scrutiny level that the court will use with commercial speech. False advertising can be forbidden. Advertising of unlawful behavior, I want to hire you to be a hitman, can be forbidden. But if it's advertising for lawful activity, it still can be regulated if the government can prove, burden on the government, has substantial governmental interest that is directly advanced by the regulation and is sufficiently narrowly tailored. Again, I'd say with all of these content-based exceptions, read the case squibs in your outline. They're not worth putting into this lecture, but they're worth your being familiar with, okay? One other point about speech before I move on, and that is something that is, at least to me, a very important point that has been tested, at least in essays. I have not seen it tested on the MBE. It doesn't mean it couldn't be. And that it kind of ties into the prior restraint concept. Suppose that a court issues an injunction against a march, an injunction against speech. It forbids Reverend Martin Luther King and his followers from marching on Birmingham. And let us suppose that the injunction is a prior restraint, which it is, and let us suppose that it would be unconstitutional, that there would be no justification for it. Does King have to obey the injunction, or can King disobey the injunction and raise the legality of the injunction on appeal from his being held in criminal contempt? Well, this actually happened. Martin Luther King was thrown in jail, from which, or in which, he wrote his famous, very famous, letters from the Birmingham jail. But one of his other people, one of his followers, raised the question on appeal, went up to the Supreme Court. This injunction against my behavior was unconstitutional, therefore I cannot be held in criminal contempt. And the Supreme Court held in Walker versus the City of Birmingham that if there was an injunction, even if it was clearly invalid under the Constitution, there was a duty of the citizen to obey the injunction and raise the case on appeal, rather than disobeying and trying to raise the issue on appeal of his being held in contempt. Obey the injunction and raise your issue on appeal. Don't disobey the injunction and think we will hear it on appeal. Might seem surprising. You can disobey an illegal statute and raise constitutionality on appeal. You cannot disobey an illegal injunction and raise that issue on appeal. Theory, Walker versus City of Birmingham. The courts, even when they're wrong, need to be obeyed. Otherwise, we have chaos. And if we're going to have respect for courts that make right decisions and wrong decisions, you must obey the injunction first, raise the issue on appeal. If you choose, as King did, to disobey the injunction and you are thrown in jail, civil disobedience, that's fine, but you can't raise the issue of the constitutionality of the injunction on appeal. Walker versus City of Birmingham. Next brief topic. Along with the freedom of speech as such, there are cases involving whether there's special rules for freedom of the press. In fact, mostly the press is entitled to the same freedom of speech as everybody else, and everybody else is entitled to the same freedoms of speech as the press. But there are a couple of issues that are particular and specific to the press. Number one, the press is entitled to publish truthful information even if it was obtained unlawfully, so long as the particular publisher didn't participate in the illegality. So if someone brings me something that they obtained illegally and I'm the press, I can publish it because I did not participate in the illegality. as long as I'm publishing truthful information. A famous case in which there was a recording illegally made of a discussion between people pertaining to union matters, and these union officials were saying things very, very embarrassing to them, but the conversation was recorded. It was illegal under state law, but it was given to a radio station that then played it over the radio. The radio station had nothing to do with the making of the illegal recordings, and so they were fine with publishing it. Couldn't be punished for publishing it. Number two, there is generally a right in the public and in the press to attend criminal trials, with some very narrow exceptions when it's really, really important. And number three, the press often claims that they should have a privilege from having to testify about their sources. This issue is raised, we are called to the grand jury, or we are called to the criminal trial and asked, what was your source of information in that article that you wrote for the New York Times or the Washington Post or the New Haven Register for that matter? And the reporter says, I refuse to answer on the ground that I'm privileged as a reporter. If I have to speak, it will chill the press because people will not talk to me. Pretty good argument, but the Supreme Court has not recognized a privilege in reporters, and a reporter who refuses to answer questions when properly subject to subpoena in the court can be held in criminal contempt and put in prison and held until the trial is over. Next topic, briefly, the right of association. Right of association. Similar to speech, because if one is associating with other people, that's often for the purpose of gathering backing for particular points of view. The NAACP, the National Rifle Association, associations, the Sierra Club. These are associations of people. The Communist Party, the Republican Party. These are associations of people to promote particular beliefs that have something to do with the speech that they might make. Can the government punish someone for associating with other people? This mostly came up in the context of communist associations back in the 50s, and the answer is only if the person knows and believes in the purposes of the particular organization, and the purposes of the particular organization are to conduct illegal activities to overthrow the government of the United States, is involved in the organization in that sense. Otherwise, the government can't punish someone for just mere membership in the Communist Party, let alone for mere membership in the NRA or the NAACP. Again, read the case Squibbs on the right of association. We are now done with speech. So far as this brief introduction, we have those general considerations at the beginning: vagueness, overbreadth, discretionary enforcement, prior restraints. We have rules pertaining to speech, regulation of speech when it's content neutral. Are we regulating content neutral speech in a traditional public forum, in a designated public forum, in a limited public forum, or in a non-public forum? And for the traditional public forums and designated public forums, we have a special rule. Is the legislation narrowly tailored to promote an important governmental interest while leaving open alternative avenues of communication? It has to be time, place, and manner regulation, narrowly tailored, promote important governmental interest, alternative avenues of communication. With the limited public forum, has to be viewpoint neutral. Content-based regulation, our other big topic, we apply strict scrutiny, the general strict scrutiny test that we talked about before, which is government has burden to prove, compelling interest, and that the regulation is necessary to that compelling interest, unless the legislation pertains to one of those accepted categories where a lesser standard applies, and those include incitement to imminent lawless behavior, fighting words technically, but in reality, they're always too vague, obscenity, special rules for obscenity, and lots of sub-rules that I did not go into that you need to read about, defamation, and commercial speech. That's the essence of the First Amendment. And in those areas, you're going to see probably 4 or 5 questions on the MBE. Very important. Go through the case squibs, the material and press and association, and we're done. Final topic, religion. The Constitution has 2 provisions protecting religion. It says that people are entitled to protection in the free exercise of religion, and we are protected against the state or the feds, both states and feds, against their establishing a religion. 2 big areas. Based on my observation from the release tests, probably 1 question on free exercise and 1 question on the Establishment Clause on a typical MBE. That's not trivial, right? Free exercise. May the legislature, whether it's Congress or the state legislature, pass legislation that makes it harder for people to carry out their religious beliefs. Well, number 1, it can never punish anybody on account of their beliefs. It can't say, you believe in something that you should not be allowed to believe in, we're going to punish you. Never can the state punish someone on account of their beliefs. Never can the state determine whether a particular religious belief is reasonable or not reasonable, because that would be intruding on freedom of religion, freedom of conscience in a totally inappropriate way for the state in our system. But what if the state or the federal government has regulations of content of behavior that are generally applicable, not just to religions, but to everybody? Nobody may use peyote. As long as the legislation is not discriminating against religion, is not separating out religion from rest of human life, it's perfectly appropriate for general legislation to apply to everybody, including a religion, even if the impact on the religion is negative, because it's a regulation of conduct of everybody. It's not a particular regulation of religion. Exception where we find that the state was regulating a religion and preventing free exercise. The infamous case in which the city of Hialeah in Florida made killing of animals, slaughter of animals, illegal, but not the slaughter of animals for all purposes. It didn't forbid killing animals to make hot dogs, killing of animals to make steaks to sell in supermarkets. It made killing of animals as part of a religious ceremony that was essential to a religion that was not popular in the city of Hialeah. It happened to be a religion of people from the Caribbean, minority groups, and they used animal sacrifice in a way that was reminiscent of what took place in the Bible all the time, and it forbade that kind of killing of animals, religious killing of animals, as opposed to any other killing of animals. Supreme Court said, no, that is directed against a religion and violates the Free Exercise Clause. Done. Read case squibs. No establishment of religion. Well, clearly that would forbid the United States from saying, okay, from now on the official religion of the United States is Catholicism, is Southern Baptism, is Catholicism, is Judaism. Can't do that. That's obvious, right? That's too simple. No issue. But can the government, either the U.S. government or the state government, do things that support or promote religion or discourage a particular religion, that show some preference for one religion over another, or that support the religion in carrying out its functions? There's a tremendous amount of case law on this. Again, I'm going to suggest you read the case squibs carefully and understand that the older test for Establishment Clause cases is that a government expenditure has to have a primarily secular purpose, cannot be intended to promote or detract from religion, and cannot unduly entangle the government in the religion. 3-part test. But the more modern cases have tended to move in the direction of saying what the government can't do is do something that endorses a particular religion. So if the government action is viewed as endorsing a particular religion or endorsing no religion, that would violate the Establishment Clause. Hundreds of cases simplified into 2 basic rules, done. Because the purpose of this overview is to give you a structure for reading the outline and recognizing which are the important parts and which are the less important parts, and reading the case squibs. If you follow my guidance, you will read the longer outlines that have case squibs 4 or 5 times between now and the bar. And each time you see case squibs, this is what happened in the Church of Leukemia by, I can't pronounce it, the City of Hialeah case. This is what happened on a state action issue, in a particular set of facts. You read them with a big structure in mind. You don't try to memorize them because you couldn't and it wouldn't be worth it. There are thousands of them. But when you get to question 145 in the middle of the afternoon and you have to make a call, is it A, B, C, or D? And you see, as you will see on the exam, a set of facts that is identical to a major Supreme Court case on state action, on free exercise, on the Establishment Clause, on standing. You see a set of facts that you say, oh, I read that case squib, and you intuit to the answer because you've read it even though you haven't memorized it. I think that's the value of reading the case squibs. So to back up, the whole purpose of this is to give you the overview. Now I want you to read the outline, read it through, do a class, go over questions, go back and review, and I think you'll find that the law of constitutional law will fit together very nicely in terms of this big picture overview. First, what are the powers and limitations on powers of the 3 branches of the federal government? Second, what's the relationship between the new federal government and the states, federalism, and between the states? How does the Constitution affect the relationship between the federal government and the states? Well, it creates the federal government, so there was no previous relationship, but also, that's Supremacy Clause, but also changes the relationship between the states. Full faith and credit clause, privileges and immunities clause, dormant commerce clause, all affect the relationship between the states as such. And our third big topic, which I've just finished, individual rights as protected against the federal government or the state government or both. Thank you very much. By the way, if you noticed any errors, please tell me, because this was my first draft and there doubtless are some errors or misstatements. Thank you.